And welcome to the October 2015 edition of the Roundup. We've had a pretty jam-packed month as it's the end of the CPD year, but in this video we're going to take you through 4 webinars that we think you might want to watch. If you want to skip to our discussion of any of them, you can do so, just check out the description that's below this video. There you'll also find a link to our website where you can watch all of these webinars in full. So to kick us off, Jordan's going to look at one of the residential property law webinars that we ran this month.
Thanks, Melissa. So on the 7th of October, we had Faisal Siddiq and Sally Blackmore join us, both barristers from Ely Place Chambers, for a residential property law webinar on possession and human rights issues. So the webinar covered a wealth of case law on the topic, and Faisal and Sally also very practically took us through all of the elements required for human rights challenges in possession cases. The pair had many interesting conversations throughout the webinar, a couple of these being their discussion on the importance of raising proportionality defences at the outset of cases as opposed to on appeal, and also a discussion based around exceptionality.
So early this month we ran a webinar on IP rights in data, databases and big data. The webinar was presented by Simon Stokes, who's a partner at Blake Morgan, and John Wilkes, who's a partner at DLA Piper. They looked at various IP rights that can be used to protect data and databases, and some issues and tips relating to the enforcement of these rights. They also discussed how data can be exploited. In this clip that you're about to see, they discuss the database right, which forms part of EU law.
John, you mentioned a fascinating thing about database right being a European-only right. So you made the really very good point that if you want to benefit from the right, you've got to effectively have a connection with the EU. Are you aware of any countries apart from the EU which have anything like database right?
Yeah, no, it is a good question, and it was one that, so we have a group of myself and a number of colleagues from different jurisdictions in my firm who have been looking at database rights for one reason and another, and so we decided to do a bit of a survey to find out, and we looked at about 20 or so sort of major jurisdictions around the world, and the only ones that had anything approaching a comparable right were South Korea and Turkey.
So, looking to our family law webinar for October, and on the 6th of this month we were joined by Matthew Fletcher from One Garden Court and Nicholas Goodwin from Harcourt Chambers, and they took us through issues faced when dealing with public law and children. So the webinar had a particular focus on care orders, the meaning of in need, and also the threshold criteria involved, and here we see part of Matthew and Nicholas' discussion on special guardianship orders.
There was a special guardianship order consultation that I responded to recently, and that indicated that in some parts of the country there were very few special guardianship orders being made. Thereby implication there were high levels of placement orders being made, because unlikely to be a high level of child arrangements orders being made. So it seems that there is a regional variation between family placements and perhaps an interpretation of REBS as a endorsement of look for a family placement other than as opposed to anything else, and other parts of the country which are perhaps would argue that they take a more holistic welfare approach and look at family members versus adoption and make a more generalised welfare analysis rather than looking at which of course we're not allowed to do, the linear approach of if not parents, is there a family member? If there's not a family member, should it be an adoptive placement? And I really think, with the greatest respect, it is a little bit of a muddle, both in the London area and nationally, as to how one should interpret the welfare checklist where there are family members versus adoption.
I think the 3 authorities that you cited in your talk, ending with the decision of Ms. Justice Russell, were really interesting, because historically I found that there's a dearth of authorities in which a child has been placed, and the court, whether it's the county court or the high court, has been willing to overturn the placement and extract that child on the eve of the intended adoption. But to have 3 authorities over a 12 or 18 month period, it's going to be interesting to see whether or not that signifies some kind of change.
So our final webinar looked at the really important issues of complaints handling and client care. Our speakers were Darren Cox, who's a legal ombudsman, and John Whitehouse, who's the senior ethics advisor at the SRA. Darren started by looking at why complaints handling is important, how the Legal Ombudsman's Office handles complaints, and he also provided some tips for how your firm might want to go about complaints handling. John then reviewed the SRA Code of Conduct, and in particular he looked at some issues that small firms might face. During the question and answer session, both of them looked at how the LEO and the SRA might deal with a complaint from a non-client.
So, yeah, the SRA does consider reports from non-clients. In the main, though, obviously would expect solicitors to be dealing with complaints from clients. I understand you may see things slightly differently down in terms of the Ombudsman's perspective.
Good question, and quite a broad topic, and a couple of interesting things that come up there from what you said, John. Firstly, with regard to the example you gave of a divorce, we don't presently take complaints from what we'd call third parties, so husband and wife getting divorced and one complaining about the other's solicitor. If there have been problems and the other solicitor may have, for example, been putting pressure on the other person, which they shouldn't have been, and that comes to us, that's the sort of thing that we'd be referring over to the SRA. But interestingly, our test for whether a complaint's in our jurisdiction that can come to us, one of the questions we ask, it isn't whether the person was a client. They don't have to be a client. The test is whether the person has received a service from the firm.
Okay, so that wraps up this month's roundup video. So if you don't yet subscribe to LexisNexis webinars and you would like some more information, you can visit our website, or you can also email us, or you can alternatively also follow us on Twitter at LexisUK Webinars. So we hope you found this useful, and thanks for watching.